of Law webinar series. First and foremost, we hope you all are well, that you are staying safe in these very unprecedented circumstances that we all find ourselves in. We greatly appreciate your participation, and here at the AIFC and at the Academy, we're committed to legal education, and we're pleased to offer complimentary webinar events like this so that we can continue the learning process, and quite frankly, so that we can all combat cabin fever, which I'm sure we are all experiencing in some shape or form. So welcome and thank you. The AIFC Academy of Law has as its mission to drive knowledge-based legal system development here at the AIFC and in the broader CIS region. And the Academy's approach is we're trying to create awareness of the AIFC jurisdiction and the benefits of your organizations establishing here and doing business to try to create a robust capital markets environment that will be directly invested into the infrastructure projects that are part of the government's grander long-term economic development vision. And we are going to attempt to support that effort by preparing lawyers for international commercial law practice. We have a common law jurisdiction surrounded by civil law countries and civil law codes. And we are looking at ways to basically cross-train lawyers who have different backgrounds to prepare them to operate effectively in this increasingly complex global commercial environment. So that's what this is all about today. Today's event will run from 3 o'clock until 4:30 if you're here in Kazakhstan. We have myself as the moderator, and we have 3 distinguished speakers today. 2 are from some of the leading law firms who are set up here in the AIFC, and our 3rd panelist is a senior executive at one of our most important AIFC participant companies. Let me just give a little bit of overview on the structure of the event today. We're going to leave about 20 minutes at the end of the session for Q&A. And my colleague, Jan from the Academy, has sent everyone a link, a Telegram link by email. So during the next 1 hour and 10 minutes, if you have any questions, send the question to Jan. He'll make note of it. And then when we get to the Q&A session at the end, Jan will then manage that. Some housekeeping matters. Please put your microphone on mute and keep it on mute the entire time. Also, keep your video camera turned off. That will optimize our reception and minimize any background noise that we might get. So please keep your microphones turned off. The format will be, we have several questions, and I will be asking one of the 3 panelists to take the lead on responding to the question, and then the other 2 will contribute after that, sort of as they see fit. Let me introduce our distinguished panel of specialists. First is Will Aston. Will is the managing partner at Ozara Services Ltd. Will has over 35 years of industry experience, including as CIO for a global wealth and investment management firm, and operation planning and strategy director for a major UK bank. Our next panelist is Khalel Tuganbayev. He's the head of the Nur-Sultan office of the Integrites law firm. Khalel is a lawyer with a focus on corporate law and litigation and arbitration, with experience in working for a Big 4 company, international law firms, and the Kazakhstan Economic Court. And Maksim Burak is a partner at the GRATA International law firm and the director of the Department of Services at their Nur-Sultan office. So welcome to our 3 panelists. And with that, let me go ahead and direct the first question to Will Aston from Ozara Services Ltd. Will, thank you very much for joining us today. Can you comment on this current COVID-19 crisis and how it affects the abilities of businesses to be resilient during this unorthodox period and to maintain business continuity as we together manage through this crisis? Will?
From a business perspective, I think the COVID-19 crisis is a major disruption. I mean, not just here within Kazakhstan, but actually across the globe. I mean, it's a big challenge for all of us individually, and it's a big challenge for business, large and small. There are two areas I want to highlight in how businesses are responding to the challenge. Number one, resilience. That's the ability of a business to be able to withstand and recover rapidly from disruptions. And the second area I want to cover is business continuity. And that's ensuring a business can continue to provide the services that are critical to the business and critical to the customers. Thinking about the first area, resilience. Let me give you a real example from here within the AIFC. The AIFC Court and the International Arbitration Center. Now, when we think about resilience, it's actually more about the business strategy and the business model than it is about technology solutions. And the court and the International Arbitration Center, they have a very clear business strategy. And that's to deliver justice in a way that's accessible, transparent, and efficient. So how does it work in practice for them? Well, say there are two companies that have a commercial dispute, one in Kazakhstan, one in Germany. And they've agreed that they want to be able to resolve that dispute via arbitration. For arbitration proceedings, they actually don't require, within the AIFC, you to be physically present, actually in the International Arbitration Center. Indeed, neither do the arbitrators need to be there physically. So arbitrators, for example, they could be one in Singapore, one in London. And the arbitration proceeding can continue with the parties located in multiple places around the world, even during a business disruption such as this with COVID-19. I also want to just touch on, for the arbitration center in particular, the question of efficiency, which again was a key part of their strategy. Some people find arbitration a very, very effective way of resolving disputes, and it's very attractive. In arbitration, for example, actually the arbitration is kept confidential. But say if you were seeking arbitration from one of the major centers within arbitration centers within Europe, actually your arbitration may be backed up maybe 12, maybe 18 months. So there'll be that period of time even before you could start your arbitration proceeding. So from a business perspective, that's not very efficient. Now, the International Arbitration Center here in the AIFC, it doesn't have that backlog. It also allows participants, people to be able to opt in to arbitration. So even if your business isn't an AIFC business, if you included the right clauses within your contract around dispute resolution, you have the option to be able to resolve any dispute you have via arbitration. Typically, disputes going on for a long time is a very, very bad thing for business. So the ability of the International Arbitration Center to be able to provide very quick, very efficient dispute resolution really can add to the robustness and resilience of the businesses themselves, because they're not going to be waiting to be able to resolve that dispute and have that hanging over them. And that applies whether the business is based in the AIFC or whether it's based elsewhere in Kazakhstan. Coming back to the question of business continuity, ensuring that a business can continue to provide the services that are critical to you and your customers. Now, this is different for resilience, which is actually about the whole business. With business continuity, this is about the specific business services that are critical for you as a business. Now, let's take an example again within the AIFC, with the Aston International Exchange, the AIX. The service that the AIX provides to brokers so that they can trade on the exchange is a really good example of what would be a critical business service. The AIX really can't function unless it's got the ability to be able to provide that trading service to the business. Now, not all services that a business has, not all the business functions are actually going to be critical. Trading certainly would be critical for the AIX. Maybe their annual business planning cycle, not so critical. So part of business continuity involves identifying and prioritizing those services that for you are absolutely critical. Critical services for AIX, obviously trading. For a bank, it may be their payments processing or ensuring that the customers actually have access to their money. Now, the time that it's tolerable for a disruption to actually impact those critical services, that again varies. So for the AIX, which actually has continued to do business during COVID-19, the maximum tolerable downtime may actually be less than a day. Whereas for a law firm, the maximum tolerable downtime may be considerably longer than that, a number of days. So in summary, our perspective is that COVID-19 is a major business disruption here in Kazakhstan and across the globe. But businesses are responding and they're leveraging their areas of resilience that they built into their businesses to be able to help weather this and withstand it. And they're also seeking as quickly as possible to be able to get the services that are critical for them back up and available to the customers. It's a big challenge for us as individuals, a big challenge is for businesses large and small, but what we see is people leveraging their resilience that they built in and focusing on the critical business services that they require and are important for their customers.
Great. Thank you, Will. That was very insightful and very helpful. One big takeaway from this crisis as we manage through it and emerge and sort of start afresh, I think there will be a lot of lessons learned. So we need to focus on some of the positives that could come out of this from a risk management and a business resiliency standpoint, as well as personal safety issues. That was very helpful and insightful. Thank you. Khalel, do you have any comments on the same topics of business resilience and maintaining business continuity?
No comments, actually. I fully support Will Aston regarding the arbitration and that this is this alternative dispute resolution is totally flexible for each party, so and not time consuming comparing to litigation. So I think this is I full support here.
Thank you very much, Khalel. Maxim from the GRATA firm, what would your observations be on this? And have you do you have a sense as to how some of your business clients, might be dealing with this topic of resilience and continuity? Maxim, what are your thoughts?
Well, yeah, first of all, I also do not have any significant comments to Will's speech. I guess everything is very well described. And concerning the questions, well, from what I see with our clients, basically the picture is quite similar in all the spheres. People try to go online, people try to minimize any movements around the city, etc. So, well, it's quite hard for me to discuss the mechanics which can be used for production companies, etc., because this is completely another world and another story which I'm not very competent about. But about the consulting services, about the things which can be done online, of course, yeah. Nowadays, the situation increases the demand for those online systems like the same Zoom or any other features, and it also increases the demand for the regulation of those remote working in terms of the relations with employees of the companies and in terms of relations between the commercial parties. But the last part, I guess, I will also describe in my speech concerning the force majeure events, etc., because well, it takes too long in terms of just responding to this question.
Thank you very much, Maksim. And in fact, that's a nice transition. I'd like you to please address first among the panelists our next question. Can you describe for us force majeure clauses in a commercial contractual setting? And then part two of this question is, what do you believe will be, or what currently is the possible application of these clauses in the current situation, which has clearly frustrated the performance of many contracts?
Yeah, thank you very much for the question. So first of all, concerning the nature of the clauses of the provisions and the provisions themselves about this topic, about the force majeure, etc., I would characterize those as not very well adapted for this kind of situation. So, well, I would also say that the nature of those clauses is quite conservative, indeed. And there is not too much differences between Kazakhstani legislation and AIFC legislation, as it will show further in my speech. So, first of all, in order to apply any kind of force majeure clause, you need to have an obligation which is breached, and you need to have a connection between this breach and the force majeure event. So, as well as you all aware, President of Kazakhstan imposed a state of emergency throughout the whole country, which further was extended. And the decree on this state of emergency, it inter alia introduces the limitation on functioning, the large trade objects, suspension of activities of shopping and entertainment centers, cinemas and other objects, and restriction on entry or departure of foreigners in Kazakhstan or outside of Kazakhstan, etc. So the imposition of those measures is per se, well, if you look strictly to the law, it cannot be considered literally as a force majeure event, because Kazakhstani law does not mention such kind of events, state limitations or actions of state bodies as force majeure events. However, in practice, and it is very regular practice, those events are recognized by the courts as force majeure events, as those acts of God, I would say, and therefore, well, we can't treat those events as excusing us for breaching an obligation. However, there is also some, I would say, restrictions and limitations to that application. So first of all, according to Kazakhstani Civil Code, a person who has not fulfilled or properly fulfilled its obligation in carrying out entrepreneurial activity shall be liable unless that person proves that proper performance was impossible due to a force majeure event. And the Civil Code gives a couple of examples of such kind of events. It's natural disaster, military operations, etc. So this provision actually shows that, as I said, you need to have an obligation which is breached, and which is breached exactly because of this force majeure event, or you should at least be able to put a clear causal relationship between the event and your breach of obligation. This actually means that, so we also try to put some kind of examples for us. This actually means that, for example, if someone like a business entity has some area rented from a landlord, this entity cannot simply say that, gentlemen, I cannot get to my place because of this of the limitation throughout the city, and that is why you guys are breaching your obligation. Well, basically, this can be treated incorrect because the landlord didn't restrict you from getting into the place, and you also is not like restricted or limited in making actual payment to that person, which means that from Kazakhstani law perspective, this mere fact of the impossibility to get to your rented place is not. It is barely considered, can be barely considered as a force majeure event, and therefore you can be barely considered as excused from your obligation to pay for this, to pay your rent. This shows that, well, as I said, the provisions of Kazakhstani law are not very well adapted to this particular kind of situation. Well, if you have a clear natural disaster, which may be not so widespread like the pandemic we have, but maybe more expressive, like fire, like an earthquake, etc. This is much easier to deal with in terms of the legal part, comparing to this worldwide pandemic. Similar provisions are provided by AIFC law, and well, I wouldn't stop on description of those provisions because basically they're quite similar, with I think a sole significant exception, which is about performance of monetary obligations. So AIFC acts clearly state that if a party who is obliged to pay money does not do so, the other party may require payment notwithstanding the force majeure event. So in Kazakhstani practice, according to Kazakh law, it is extremely difficult to prove that you were unable to pay some monetary obligation because of force majeure event. But eventually, at some point, with a very significant amount of proofs, you can do so. But this is rather a theoretical thing, not a practical one. But in AIFC law, you just clearly prohibited to rely on force majeure in terms of breaching your monetary obligation. So, yeah, as I said, and also lots of sources position the AIFC jurisdiction as the one applying English law. This is just like kind of nota bene about that. It should be remembered that AIFC law is not English law. It is a system of acts adopted on the basis of English law, but this is kind of different legal system. And therefore, there is a position among AIFC officials. I'm not sure we face this in practice in courts of AIFC, but nevertheless, there is a position that you cannot simply apply English law customs and English law doctrine in terms of interpreting the AIFC law, in terms of proving these or that circumstances, and in particular in terms of proving you have a force majeure event. And this whole situation brings us to the following. In order to get yourself covered from this kind of situation, it is necessary to carefully put this into the contract drafting. I don't see any other available way here, of course, except for amending the law, but this is quite a long way, to get yourself covered from these kind of things. Because, as I said, unless you are prohibited, unless you find an obligation which is breached by a particular party, you cannot rely on force majeure. And of course, obviously, unless you also have this causal relationship between the force majeure event and the breach of the obligation. So, yeah, I think that's it about the force majeure. About the frustration provisions and those relating to non-performance, well, basically they were similar. I'm not sure we have anything significant in AIFC law, in Kazakhstani law, concerning any kind of frustration brought to the whole business. And about the possible application of such clauses in the current situation, as I said, well, this will be a repeat of myself. You need to have an obligation and you need a causal relationship clearly. Otherwise, at least from formal perspective, it is you're not excused for breaching an obligation, etc. It is really possible that in some cases the courts in AIFC or in Kazakhstan will interpret the provisions concerning the force majeure more widely. I mean, not follow the literal interpretation, but try to interpret them in whole, in the context of the whole situation. There are such kind of cases in at least in Kazakhstani law practice, but I wouldn't say we can rely on such kind of behavior from Kazakhstani courts. Well, I think that's it about the force majeure clauses in terms of the contracting law. We have some things which can be useful in terms of dealing with the AIFC as the regulator, but I guess this is the topic for another part of the discussion.
Excellent. Thank you, Maksim. Khalel from Integrites, can you comment on force majeure clauses, both from a legal and a practical standpoint?
Yeah, I have some comments. Many of our clients also request legal advice dedicated to force majeure currently. And Kazakhstan legal and business market should be aware now that there is a real risk that force majeure circumstances may appear in any cases. I fully support Maksim's comments here that force majeure events frequently occur. At first glance, this risk might look not high, taking account that the latest global pandemic was about 100 years ago. I mean, Spanish flu. But force majeure may happen in any country and anywhere, and not only due to disease. And for example, in Kazakhstan, what comes to my mind? It's maybe earthquake or a dam in Almaty. By dam, I mean a barrier that stops or restricts the flow of water from mountains. In Russian, we call it damba. So in Nur-Sultan, for example, it may be winter storm, which is really unbelievable. I believe my colleagues from Nur-Sultan, Will, Maxim, and David, you as well, will support me. Winter in Nur-Sultan is deadly. I am from Almaty, which is, the one of the sunniest city in Kazakhstan. And 2 years ago, I moved to Nur-Sultan. I already survived 2 unbearable Arctic Siberian winters here in Nur-Sultan, and it was really tough moment of my life. By the way, do you remember a movie starring Leonardo DiCaprio, a movie about a man in the journey which took place in the about 19th century, who fights for survival after being injured by bear in the dead of winter? So Leonardo DiCaprio actually has won Oscar for that movie. I don't remember the name in English. In Russian, we call it Выживший. I guess it was called in English The Revenant. So, I mean, guys, I believed that I deserved this Oscar more than whoever, even insanely adorable Leonardo DiCaprio, And I mean, force majeure can appear anywhere, anytime. So concentrate, even you are practicing lawyer at the law firm, you should concentrate while you're drafting force majeure provision. You should concentrate on this as well. Anyway, that's the end of my comments, David.
Good. Thank you very much. Will, from a business standpoint at Ozara, do you have some comments on the practical implications of force majeure clauses?
I do. I think it sometimes surprises people quite how frequently the force majeure events actually occur. Flu pandemics, as we know, like COVID-19, they may be 3 times in every 100 years if we look back over history. But actually, depending on your location, things like storm and flood are much more frequent. Fire is the one that actually pretty much universally is more frequent everywhere. And there are some businesses, particularly for fire, that are at greater risk of fire. I mean, that includes things like retail, restaurants, cafes, industrial premises. So the other thing to note is that actually the business's response to force majeure may vary. So even if it's essential that you have these clauses in there, but actually the way in which these clauses are specifically crafted is actually going to vary from business to business. And it's important to recognize that yes, you'll have the legal protection so that there's a delay or you can't meet your obligations as a result in your contract as a result of that force majeure. But what you need to be able to do in response to that is actually going to vary very, very significantly by business. And that will actually mean that in a lot of cases, your force majeure clause will actually look different from one type of business to another. Let me just give you an example of that. Actually, in the banking industry, it's quite common for alongside your force majeure, because that's things that are outside your control, to also put into your contract, next to that or as part of that particular section of the contract, the things around sanctions. Because again, that's an event that is outside the bank's obligation. So it may not be able to execute the instruction that they may have from their client. It's not within their control. And therefore, from a legal perspective, you're trying to put the same sort of protection around it. But the main thing is that every business should have the force majeure clause as part of its terms of business, so that it gets included into every contract that it has.
Thank you, Will. Okay, let's move on to question number 3. Khalel, let's direct this one at you to start. Now, here's a topic that I am relatively certain that many of us on this call are dealing with, and that is, can you comment on this topic of using scanned and emailed or electronic signatures on legal documents that at least as of now are not recognized in many jurisdictions? Can you comment about this need, and is there an established practice in your company as how you are, or in your firm, as to how you're dealing with this situation?
Mm-hmm. Good question, David. Thank you. Electronic signatures and email contracts, scanned contracts are all used in digital communication. And taking into consideration ongoing pandemic of coronavirus disease 2019, it has become increasingly important to consider how to execute contracts when parties are separated by location. And thank God for that. In Kazakhstan, electronic signatures, electronic contracts, scanned contracts are already well recognized by our legislation. So under Article 152 of the Kazakhstan Civil Code, written transactions may be made in hard or soft copies. Transaction in writing is equal to exchange of letters, faxes, electronic documents, electronic messages, or other documents determining subjects and content of their expression. So regarding the question, what is the better for business, scanned contracts or originals? In my opinion, it is a double-edged weapon. I mean, it depends. On the one hand, to conclude scanned contracts is extremely fast. On the other hand, they are not recognized as original documents for judges of KZ courts, even arbitration in Kazakhstan. So you anyway need original documents on paper if you have any disputes against your counterparty. And also, in order to conclude scanned electronic contracts, we should remember the requirements for such contracts. So according to Article 393 of the Civil Code of Republic of Kazakhstan, a contract is deemed to be concluded when consensus on all its essential terms has been reached between the parties. So these essential terms are the following. First, subject matter of the contract. So this should be indicated clearly in the contract. Second one, the provision which are recognized by legislation as essential. So what I mean by that is, for example, frequently used SPA contracts, name and quantity of products should be clearly indicated in the contract. For leasing agreement, for example, amount and frequency of payment, terms of agreement should be indicated. So all these and other essential provisions are provided by special part of Civil Code of the Republic of Kazakhstan. And finally, the third essential term are all other provisions on which, according to the application of either party, consensus must be reached. So this is the main requirements for contract, and it doesn't matter whether it is in hard or soft copies. Going to the topic on applicability of AIFC law in the framework of electronic contracts, scanned contracts, so on and so forth. AIFC law is more flexible, which is, in my opinion, is a big advantage. AIFC contract regulations provide the following. Nothing in these regulations requires a contract to be concluded in or evidenced by writing. It may be proved by any means, including witnesses. So what it means? It means that contract may be concluded via inter alia electronic means. It is also noteworthy that comparing how the contract appears in the framework of Kazakhstan law, a contract under AIFC law appears between two parties via offer and acceptance. That's all. So you don't need, as under Kazakhstan law, to adhere, as I listed above, essential terms, etc. So that's why under AIFC law is more flexible. Moreover, I think lawyers should keep in mind that being not an AIFC applicant, participant, you are able to opt for AIFC law and conclude the contract under AIFC contract regulation. So I think this is the one of the main points regarding the that AIFC law is more flexible. As a lawyer, I have to say about risks arising out during the signing, scanned, and original contracts. This first is proof that both of the parties have original copies. I mean, once you are sending a hard copy via postal service company, for example, DHL or Pony Express, sent your document with receipt notification. So this notification will be provided from postal services company to you as a party who has sent the documents to the counterparty, who has confirmed that he duly received documents. In the future, this document will be your proof in the court proceeding. Also taking account current situation with dollar, pandemic, and Brent regarding the oil, I foresee that when emergency situation is cancelled, all businesses will go to the court to recover their money. So second of all, second risk is unauthorized person to sign. So it doesn't matter whether you are in the jurisdiction of AIFC or KZL, you should assure that the person signing the contract is a person who really has this authority to sign. You may mitigate this risk by requesting article of association, or it may be called as a charter in the company, power of attorney, and any other documents in order to be 100% confident that the person's signature is valid. Third one, missing essential terms, as I said, may lead to recognize the contract as invalid. And last one, taking account that AIFC law is more flexible, make sure that all the terms which are essential for you are reached. So that's the end of my comments, David.
Thank you very much, Khalel. Maxim from GRATA, can you comment on electronic signatures?
Many thanks, Khalel. That's very interesting. And I have a couple of things to add. First of all, I guess maybe one of significant things which, as I can see, AIFC is missing now are the electronic signatures widely spread and widely used throughout the AIFC. Because as far as we can see, I mean, we've advised a couple of clients in this respect. I don't see any possibility to, for example, use the Kazakhstani regular electronic signatures in AIFC. Of course, AIFC is still Kazakhstan, which means Kazakhstani law still applies there, and since the electronic signatures are not regulated in AIFC, you can potentially use the ones issued by Kazakhstani government. However, if we are dealing with someone outside of Kazakhstan, this becomes maybe more difficult, because we need to kind of wear the foreign kind of electronic signature. I guess a system named DocuSign is widely used in this sphere, and Kazakhstani electronic signatures, and this seems to be an issue at some point. Also, I also do not see any kind of possibility to use the electronic signature in terms of reporting to AIFC. From this point, this also seems to be kind of a gray area for AIFC, because I guess this much might simplify the process a lot. And the last comment I have in this respect, if I understood you correctly, Khalel, you mentioned that it is possible to use AIFC law in transactions between non-AIFC Kazakhstani legal entities. Is that right? Did I understood you correct? Okay, thank you. So this looks very logical to me. This looks very useful. However, when I tried to issue a kind of legal opinion in this respect, I didn't find a provision which can be interpreted as posing AIFC law as a separate kind of legislation mentioned under civil code, when civil code says that you can put non-Kazakhstani, you can put as applicable law the legislation of non-Kazakhstani jurisdiction, non-Kazakhstani country. And AIFC law does not seem to me, at least formally, to be put like in this way. And that is why I guess there can be some doubts on like implementation of this approach if parties have a dispute. I'm not sure how the court would interpret this, given that both parties to this contract agreed to apply AIFC law to their completely non-AIFC relations. But at least this looks like also a gray area for Kazakhstani legislation as well to me.
Thank you, Maxim. Will, do you have any further comments on electronic signatures?
Well, the only thing I would say regarding electronic signatures or whatever form of signature or how the contract is agreed, I mean, the most important thing is actually to do the checks that the contract is going to be valid and it covers the things that need to be covered. I mean, for firms like us, we have a range of clients with different needs. They have different ways of working. So there's a range of how we do business. So I think flexibility is important in that circumstance. And maybe as a consequence of that, the majority of the contracts that we enter into are actually under AIFC law. I mean, we do have contracts under Kazakhstan Civil Code, but the majority are AIFC law contracts that we have.
Thank you, Will. Okay, so for the fourth question, we'll direct this at Maxim to start off. Maxim, which provisions of the acting law of the AIFC may be helpful in conducting business in the current situation?
So, yeah, many thanks, David, for the question. So first of all, I think, yeah, as I said previously, I don't see both Kazakhstani and AIFC law very well adapted to this kind of situation, to complete remote working. However, there are a number of provisions which can be useful in this respect. Yeah, first of all, as my colleagues just commented on me, we have recently a kind of discussion with AIFC officials concerning the electronic reporting. And it looks like potentially AIFC may be able to get the reports from the participants in electronic form as of today. However, this does not seem to be very clear right now, and this also worth additional discussions. Well, at least this potentially may be an option. Another thing is that, as you all, I think, very well aware, AIFC law provides for quite significant, at least comparatively to Kazakhstani law, quite significant fines for AIFC participants for non-performance by those of their obligations on filing annual accounts, reports, notifications, etc. At the same time, recently there was a notice from AIFSA, which stated that AIFC participants may be exempted from the fines applied for the overdue of inter alia notifications of change of registered address, final annual returns, etc., until 1st of January 2021. This notice actually combines with the provision of AIFC companies regulations, which says that on the application or with the consent of a person, the registrar may, by written notice, provide one or more of the relevant provisions to not apply to such a person, or to apply to the person with the modifications stated in the notice. What it means is that actually the regulator may provide an excuse to respective persons for breach of some terms, and in this very tough situation for the whole business, for AIFC as well, this, I guess, may be very useful, and AIFC participants, if the reasoning explained properly, may get such kind of excuse, and may, for example, may avoid the necessity to have some wet signature on some documents, or to have, I don't know, some report provided to some particular date, given the disruption brought by COVID-19 to the whole business. Also, very live question, I guess, for everyone is the distance working. Currently, most of the companies have been transferred to distance style of work, and it also should be noted that the AIFC employment regulation do not detail the distance work of employees as opposed to Kazakhstani law. I would say that Kazakhstani law is a bit more detailed in this respect, because, well, it provides some separate provisions. AIFC law is, from one point, it is less detailed in this respect, and from another point, it is maybe less restrictive in the same sense. Taking into account that under AIFC employment regulations, employment contract must include the place of work. We suppose that an employee transferred to remote working, in order to transfer an employee to remote working, it is necessary to have additional agreements to his or her employment agreement. However, given the discussions, given the information provided by Khalel about the possibility to get a contract signed remotely, this looks not too tough exercise for the parties to have this contract agreed, at least by exchange of some electronic messages, etc. Also, according to Article 12 of AIFC employment regulations, such amendments. I'm sorry, I misled you in this respect. The employment regulation says that it must be in writing and it must be signed by the employee, unless the agreement is for the benefit of employee. It is it is not very clear whether such kind of amendment is for the benefit of employee, and this was the misleading part. So if it is clear under the amendment that it is for the employees' benefit, it is quite, well, it becomes quite simple to have these agreements signed remotely by exchange of electronic messages or some other applicable way. However, if there is a dispute in this respect, eventually this may become a problem for the company. But given the whole situation, given the whole disruption and common understanding of this situation, I guess the courts should not be eventually very too much conservative in this respect. Also, considering Kazakhstan labor practice, it may be useful to cover the following issues in such an additional agreement. First of all, is to state that how the recording of working time will be conducted, because as you all very well aware, it is kind of essential part in terms of determining the final employee's salary. And also, it is necessary to state who will compensate the expenses for usage of means of communication, as well as cost of electricity, water, and other expenses used by employer during distance working. Well, at the first glance, this look quite obvious, but as far as I'm aware, large companies less conservative in this respect and seeking to provide some additional compensation to the employee, even though this employee actually stays at home and bears the same costs, regularly bearing the same costs which this employee would bear if it would be simply on his vacation. So, as I said, basically, just summarizing the above, I think the remote work with the regulator is not very well described by AIFC Acts as of today. But as I said, I guess the whole world was not very well prepared for this kind of situation, and AIFC law or Kazakhstani law is not an exemption here. And also, as it was mentioned by Will, yeah, it is possible to have remote arbitration under AIFC regulation. I will not describe this in very much details because it was described by Will also, but just I would just repeat it for the sake of consistency. Well, that's it from my side. And yeah.
Excellent, thank you, Maxim. Khalel, can you make some comments on the acting law of the AIFC and its ability to facilitate business?
I totally agree with Maxim regarding the remote working. You know, this is we also as law firm working remotely, and nevertheless, as earlier, we are 24 hours a day in close communication with our clients on various matters. Regarding remote work, I think this is advantage from one side for business now working in distance. Why you pay less, for example, for renting office rather than even when you have all personnel in the office. So and there is disadvantage also. For example, you as an employer should motivate your employee while he working remotely, and while this employee surrounded by various demotivations, such as this sofa that asks you to lie on it, and kitchen, so on and so forth. So I mean, I see that we will see a little revolution in the field of distance working, and taking account flexibility of AIFC law. I think it will help us. So that's the end of my.
Good, thank you, Khalel. Will, same question. What benefits do you see under the AIFC acting law to facilitate conducting business in this current environment?
I think Actually, it's right that employment, jobs, and flexibility of resourcing are really at the heart of this question. And clearly, AIFC law can potentially help with more flexible resourcing and remote working. And even if in your employment contracts you've got the place of work being whatever your office is, or any such place that the company may from time to time require, then that already gives you the position that you've got that flexibility. Regarding regulated firms, I think there are things, for example, in the AIFC Financial Services Framework Conduct of Business that also permit things that are very helpful if we're thinking about the question of flexibility and resourcing more broadly, in that it permits material outsourcing. So broadly speaking, what that is when a firm can outsource one of its business activities, as long as it still retains the responsibility for that. So, for example, if you were an insurer and you have claims assessment activity, and that claims assessment activity has been disrupted for some reason, having a sourcing arrangement with a third party could be helpful in those sorts of circumstances. The third party doesn't need to be in the AIFC. They could indeed be in another part of the world that's not facing the same claims assessment resource constraints that you as a firm are actually facing. So if, for example, this was in the EU, you'd also be able to take advantage of the AIFC data protection legislation, because the AIFC data protection legislation could be assured because the firm that's providing those claims assessment activities for you in the EU, they would be adhering to the global data protection regulations, GDPR. And that would mean that the needs of the AIFC from a data protection legislation are very, very easily met. So I think there are broader opportunities beyond the immediate one of remote working, where the way in which the AIFC legislation's been constructed gives you flexibility across employment, jobs, and resourcing more broadly. One other observation I would make regarding AFSA and the registrar of companies at the moment, I think that the registrar of companies is actually being very pragmatic and very helpful at this point in time. And I think we may actually see some AIFC participants, after talking with the registrar of companies, suspending their business for a period of time and then ramping up and becoming much, much more active at a later date.
Great. Thank you for that, Will. Okay, to the panelists, we have 2 questions left, and we have about almost 15 minutes left. So if I could ask the first speaker to hold his remarks to about 5 minutes, and that will get us back on track. Now, these last 2 questions are somewhat related, but they're different. So let's address them one at a time. The first question has to do with what would be your recommendation or particular solutions that you might suggest would be helpful to cope with this environment. And before you answer that, Will, and you'll be the one to start this one off, keep in mind that we're going to have a follow-up question, number 6, which is, what did your firm do specifically that was helpful? So let's stick with sort of your general advice on how businesses and firms might be able to cope with this situation effectively.
I think that there are potentially things that firms can do. But I think it's really important in looking at what you can do to recognize that what may be sensible for a national company isn't going to be workable for a small or medium-sized enterprise, and indeed what's right in one country isn't going to be right for another country. So I don't think there is a one-size-fits-all solution. And let me give you a brief example to illustrate that in terms of a solution in one country not being workable in another country. A number of years ago, I was working in Bermuda, and Bermuda, as some of you may know, like parts of the United States, is in the hurricane path and subject to hurricane storms. And I was actually there when Hurricane Fabian struck. The business response, or the federal response in the US to hurricanes is quite simple. It's go north and go inland. So people evacuate and they go north and go inland. Go north and go inland doesn't work in Bermuda. Bermuda is an island that's 26 miles long, and its widest it's 2.5 miles. So there's a very small amount of no go north you can do, and there's absolutely no go inland that you can do. So in Bermuda, they take a completely different approach to the same problem. What they do is they rest and shelter in place. And to make that workable for them, what they do is they actually have very much stronger building regulations. What they also have is they have, you may have seen the photographs, they have these white roofs, these white stepped roofs. And what these are doing, actually they're collecting rainwater. So every house, every home is self-sufficient in terms of water. So when the hurricane strikes, people rest at home. They make sure they've got sufficient food. If they need additional water, they have their own supply. So when Fabian struck, our house was back up and running in under a day. And similarly, businesses take the same approach there. You can't, for your data centers, say for the bank, they can't be the required distance apart. So again, you address it with different approaches. You increase the building regulations, you still give yourselves the things you need so that you are protected. So I think that the point about that is that the approach taken, is actually going to vary, and what things that you can use to make that sensible. So what potentially can we do here in Kazakhstan, given that there isn't a one size fits all? Well, I think there are things that we can do to make our business more resilient, and this is really about resilience, is what you're looking to do here. Yes, there are things that can be done within the AIFC, much of which we've talked about already. But I do think there are things that are part of that solution that are more unique to Kazakhstan. Digital Kazakhstan's infrastructure and the continuing rollout of that is not just making remote working a possibility for some businesses, but I think there's a whole series of solutions that can help individuals and businesses, large and small, support specific solutions for COVID-19 at the moment, but also solutions for future business disruptions. So I think when you're looking at it, you need to be very focused on what are the unique strengths that you actually have, what are the things that are unique to your part of the world, and making sure that you're building in that resilience. And maybe the combination of AIFC and Digital Kazakhstan will build the same sort of resilience that the strong homes and white roofs and self-sufficient water supply have in Bermuda.
Excellent, thank you, Will. Maksim, over to you.
Well, basically, for the sake of saving time, I would say that the comments I have are not very significant, and I prefer to keep those for us to go on the timeline.
Okay, thank you, Maksim. Khalel, do you have any further comments?
No comments, actually, so far.
Okay, well, let's continue on to the final question before we launch into Q&A, and that is, we're going to start with you, Khalel. How is your firm, the Integrites firm, managing the situation? What are some of the things that you're doing that are working? What are some of the suggestions you might have to improve how things are going?
Mm-hmm. Thank you. I have a minor comment, actually. As any other company in the market, I mean, even as construction company, as FMCG company, IT consulting company, so on and so forth, we totally understand that this is not the best of times now. We, as any other company in the market, work remotely. as I said before. Nevertheless, as earlier, we are 24 hours a day in close communication with our clients on various matters. So, and the transition goes well. In terms of our internal procedures regarding the way we deal with current situation, for example, I'm in close communication with seniors, as usual, with peers and juniors. We inform our clients, by the way, on current trends via newsletters. And I think now we have become even closer to our clients, since they need us more than ever before. So, and we learned a lot from current situation. First is, as Maksim told, force majeure provision in contract is important. The second is even only one day off for business in the world, it may significantly impact on the global economy. And the final one, the third one, is while working on, as I said before, on soft copies of documents, make sure that you have original ones, because taking account current situation, all the companies will go to the court and file claims against you or even your counterparty or your subsidiaries. So that's end of my comments, David.
Thank you very much. And panelists, thank you. We're back on track. We have about 5 minutes left. Will, can you make some comments about some of the things Ozara has done to really mitigate risk and keep business moving in this environment?
I mean, like others, we are remote working, and that's working for us. Some of the other businesses we see, this is actually not so easy. I think law firms and consulting firms are able to take advantage of remote working, potentially more than others. But I think, irrespective of the nature and size of your business, it's important to recognise that you know, COVID-19, particularly with the dual shock of the oil price, it's a major inflection point for businesses. And as a major inflection point, actually, the cost of inaction is really, really high, both in economic and social terms. But history tells us actually that the payoff for action is also really, really large. And let me give you a very quick example of that. The Bank of Italy, which was established in San Francisco in California in 1904, serving the Italian American market. 2 years later, it was subject to the earthquake and fire of 1906. And the Bank of Italy survived the fire and took action very, very quickly to provide loans and rebuild the city. And they, as a company, have grown and grown and grown. And they're now the 13th largest company in the world. And you may know them better as the name that they changed to in 1930, as the Bank of America. So my hope is that people will be taking action in addressing this. And if we do, I think that you know, we may well see emerging out of this a number of successes similar to the Bank of Italy to a Bank of America story.
Great. Thank you for that, Will. Maksim, what are some of the things that the GRATA firm has undertaken to manage things through this crisis?
Yeah, many thanks. So first of all, not gonna lie, the whole crisis did not significantly strike our working process at all. I mean, in terms of the process itself, because well, we are used to have lots of phone conversations with each other. We use a project management system, which basically allows to distribute tasks amongst us, etc. So, well, what changes and what we do to prevent that is basically the work with the state authorities. Of course, this is much more difficult now, but we deal with this using the courier services. And yeah, particular negotiations are sometimes more difficult because of the impossibility of personal meetings. However, what we do, I mean, what I think can be treated as we do to avoid this crisis, to keep the process going, is the use of this project management system. I wouldn't advertise ours, that's why I just keep the name, but it's just a waterfall project management system, and we use emails as regularly, we have phone conversations, and well, basically that suffice. And that is the way we regularly worked before, so that is why it didn't strike us too much. But of course, in terms of hiring clients, that's a much more difficult situation here because of lack of personal meetings, etc. But now we stick with online events like this one, maybe some webinars additionally, putting some additional articles to the internet, something like that.
Excellent. Thank you very much, Maxim. So now we're going to move to the Q&A portion of the activity today. We did receive one Telegram question that came in. So I'm going to go ahead and read that. And this is directed to Mr. Khalel Tuganbayev. And once we cover this question and Khalel responds to it, we will move to a format whereby on your screen, there will be an opportunity to raise your hand to ask any additional questions, and my colleague Jan will be managing that. But first, let me go ahead and read this first question, again directed at Khalel. This is from Alua Benditova, and she says, a year ago, a contract was signed in hard and soft copies. During this year, the counterparty did not pay for supplied goods under the contract. The problem is that there is only soft copy left. The original one was probably lost. What is your advice on this situation? How can we recover our money?
Okay, thank you very much for question. Very interesting. Lack of an original copy of the contract is a problem anyway. So if you refer to the court, the judge anyway will request from you an original copy during the court proceeding. And in my opinion, the judge most likely will not issue a decision without this fundamental document of this dispute, or issue a decision against you. It is most likely. It depends anyway. You may consider the following. Maybe you will try to send a claim letter to your counterparty requiring to recover money, and maybe he will recover that money in specific date indicated in that claim letter. Or second, during the court proceeding, if you file the claim, you may ask the judge to rule on requesting original documents from your counterparty, I mean, disputing party. But in my opinion, there is a high risk that your counterparty will say that they also lost the original documents. And finally, the third option, and I think based on my experience, every case is unique, and I mean, everything depends on dispute itself. Before going to the court, ask any advice from qualified lawyers which focus on litigation and arbitration. They will review all the documents and come up with the right decision and proper steps to recover your money from a bad guy. So that's the end of my comments, David.
Thank you, Khalel. Okay, so that was the only question that came in by Telegram. And now my colleague Jan will basically take over the screen, if you will. And the participants have the ability, if they look to the bottom of their screen, there should be an icon that appears that allows you to raise your hand to ask a question. So please feel free to do that. And anyone who would like can go ahead and participate that way. Just remember, turn on your mic and turn on your video camera so we can see you. Any questions whatsoever for any of our three lecturers?
David, I guess there are no questions, so we can wrap up the conversation. Maybe a few last words from you, and we're good to go.
Absolutely. Okay, thanks so much for your participation. Just so you all know, there were 73 of you on the line for the most part, and we really appreciate it. We hope you enjoyed today's session. I want to thank our speakers, Will, Maksim, and Khalel, for volunteering their time and helping the Academy in its mission to disseminate information, answer questions that might be on your mind relative to practicing in the AIFC and the broader Kazakhstan jurisdictions. More to come. We're offering these webinars on a weekly basis. This week we had 6. We'll be averaging probably about 2 or 3 per week from here. So please stay tuned, stay in touch with us, and by all means, be safe. Thank you very much, everybody.
Much.
Goodbye.
Bye.
Bye.